I was quite staggered to read a story reported by The Sun this evening about a £70 charge for someone that parked for 13 minutes outside the store when the store was closed. Apparently, because of boy racer rules, the store has decided to clamp down on people driving recklessly on their car parks after hours. That's fair enough. However, I would object to this on the basis that the Consumer Rights Act provides that if a term in a contract is found to be unfair, then it's going to be unenforceable against the consumer. Allow me to explain. So in Schedule 2, Part 1 of the Consumer Rights Act, there's a list of terms which are deemed to be unfair. And if they're unfair, they're unenforceable. So let's break this down for a moment. So if there is a parking restriction on the car park for Asda, which says that you cannot park on there after hours, i.e. when the store is closed, otherwise you are going to pay a charge, a parking charge, which is ordinarily issued, let's say if you're overstaying or parking incorrectly and things of that nature, then that would ordinarily be perfectly fine. However, whilst the store is closed, gives rise to certain considerations here. So this person reportedly drove on, intending to shop there, found that it was closed, Googled where else was open, and then left after about 13 minutes. Now, under paragraph 18 in this Part 1 of Schedule 2 of the Consumer Rights Act 2015, the example is as follows. A term which has the object or effect of obliging the consumer to fulfill all of the consumer's obligations where the trader does not perform the trader's obligations. Now, this would be an example of a term which would be regarded to be unfair. So let's break that down for a moment. A term that has the effect of obliging the consumer to fulfill the consumer's obligations. So in other words, if there's a term within the contract of parking on the car park which says that if the consumer parks there outside of the ordinary permissions, then the consumer is going to pay this £70 charge. However, if that term also provides that the trader is not going to perform their obligations, and in this situation the trader is closed, so it's an ordinary mistake and the trader cannot and does not perform their obligations, but the consumer is required to fulfill his or her obligations, i.e. the £70 charge. In my view of that, it's going to be an unfair term. If this went to court and this individual said, I mistakenly drove onto the car park hoping to shop at the store, found that it was closed, found where else I was going to instead, and then set off, and referenced this particular example in the Consumer Rights Act, in my view, that would mean that the consumer is forced to comply with his or her obligations, but the trader is not, because the store's closed. Now, if it were found that this car was just parked there all night, that's a different story because there's no implication there that the person parking was even hoping that the trader is going to fulfill their obligations. But in this situation, the person parking obviously wanted to shop there, and this term effectively meant that the consumer must uphold their obligations, but the trader does not. So in my view, this is likely to be unfair and therefore unenforceable in this particular set of circumstances. But of course, this is just my view going on the briefest of details and cannot be taken as legal advice by you, and you must seek formal legal advice if you need to. But in any event, I hope you found this useful. Please share it with someone that you think will find it useful. Please like it and subscribe if you like these kind of videos. And as always, thank you for watching.